Hello, I'm Sandy Glazier, and I'm an attorney in the law firm of Lips and Nielsen in their Bloomfield Hills office. We have offices in Michigan, Arizona, Colorado, and Nevada. This morning, I've been asked to speak to you about some of the benefits of communicating with your clients and prospective clients about potential changes in the law that could impact in a significant way estate planning that's already taken place or plans that clients are contemplating right now in order to use up the balance of their lifetime exemption. Next. Marty Shankman, Abigail O'Connor, and I had an opportunity to do a webinar where we're addressing some of the changes, the prospective changes, and how one might contemplate those changes in drafting estate planning documents and reviewing estate planning documents for clients. We decided to come up with some sample letters that might be used by practitioners to advise their clients about the potential changes and how they might impact their estate planning analysis. Those letters were then submitted as an article to Lisi, and they are now included in your materials here today in the PowerPoint. The first letter is a longer letter that goes over quite a number of the proposed changes, planning options, and potential implications. Now, we recommend to practitioners that they look at these letters, they take what they like, they leave the rest. When Marty and I utilize these letters for our individual clients, as did Abigail, we also included very state-specific issues. I added provisions that related to the use of ladybird deeds, which some states recognize and some states may not recognize, but there was a recent case dealing with what happens if there is a casualty loss between the date of death and the date the contingent beneficiary takes out insurance on the property. So I had added a provision about that in my state letters. Marty added some provisions relating to changes in New Jersey and New York laws. And Abigail added some language specific to her state. So when you review these sample letters, think about the jurisdiction in which you're practicing or your clients are located. And if there are some additional issues that you might wish to alert your clients to, consider adding them to the letters when you utilize them. Next. So this first sample letter is the longer letter. It goes through the proposals that were made by Senator Sanders, Van Hollen, as well as proposals contained within President Biden's Green Book. They go through them in greater detail. It represents a longer letter with more planning options, as well as some of the pitfalls that may befall us if we use current options that are available and some of these proposals are enacted into law. Next. As you could see, it went through the Sanders proposal, but more important to our analysis and creating greater uncertainty for estate planners than I can recall in the almost 40 years that I've been practicing law are proposals contained within the Van Hollen and the Biden proposal that will result in triggering events, the loss of step-up in basis, and the potential for imposition of capital gains taxes when no disposition of an asset occurs. As a result of some of these proposals, they could have a significant impact on such things as grantor trusts, which we have typically used when drafting irrevocable trust instruments in order to provide for taxation at the grantor's level, and the ability to further deplete a grantor's estate by making what we would consider gift tax or estate tax-free transfers to pay the tax consequences during the grantor's lifetime of sales and dispositions within those trusts and the income generated by those trusts. So these proposals could have a very significant impact on the irrevocable types of estate planning we're contemplating on behalf of our clients in order to use up the remainder of their lifetime exemptions, which are at all-time highs. Nobody has a good handle on what will be enacted, but we anticipate that income taxes and capital gains tax rates will likely go up, but the balance of our Ouija board is not operating the way it should, and the pointer goes all over the place. And my crystal ball has been cracked. So I cannot predict and foresee the future, but it's important for our clients in making informed decisions to consider the potential implications of proposals that are currently on the table. There may be additional proposals that come out that could also impact how we view things, but these are already in place. And the Van Hollen proposal also contemplates a retroactive effect to 2021, while the Sanders proposal doesn't contemplate going into effect until January of 2022. And Secretary Yellen recently indicated to the Senate that she would not view the capital gains tax change being implicated in April of this year to be a retroactive modification. So all of those comments and proposed changes are things we have to think about while we're trying to advise our clients. And we felt that providing a letter to our clients about these potential changes permitted them to make better and more informed decisions, even though we can't recommend any perfect solution to the estate planning dilemma we find ourselves in as we try to use up the balance of our clients' lifetime exemptions before they either are reduced or sunset. Next. So we talk about protective steps. We made recommendations in terms of the types of assets a client might consider using to fund their irrevocable trusts now in light of the potential capital gains tax consequences that might be imputed to such transfers. So it seems safer to transfer cash or highly appreciated assets or borrow against assets so that these trusts can be funded with cash. But many of these issues are addressed in the letter. The first letter, the version 1, which is on the screen right now, addresses also changes with regard to generation skipping transfer tax, which some of the proposals consider eliminating the exemption for exempt assets at regular intervals, which has not historically occurred under the current estate planning regime. Next. So it's impossible for me to read through all the changes that we're discussing, but if you look at these letters, and we're going to flip through some of them pretty quickly, you'll see there's a consistent pattern in at least either nominally or in a more expansive fashion, laying out for the client what these proposals currently entail and that they may have an impact on the client's estate planning considerations and desires. Next. In the first letter, there's also a discussion about some recent case law changes that impact the benefit or the use of complex insurance in planning, and also the Secure Act. Later letters do not really fully address the Secure Act because both Abigail and I had previously sent out letters to our clients regarding the Secure Act, so we did not duplicate information on the Secure Act in our most recent letters. Next. So we also provided for you 2 simpler letters, and those are format 2 and format 3. But as you can see, both letters are sufficient to at least alert your clients to the proposed changes and the need to consider those proposed changes in formulating their estate plan. Next. It's a pretty scary time for us as estate planners, as well as for our clients, when these paradigm shifts in how trusts may be taxed, how GST exemption may be eliminated over a period of time. And so, and the effectiveness of plans such as GRATs, which we've historically used in a more laddered or tiered approach, may not be as effective as they were historically because of proposals addressing how long a GRAT may have to run and what the residuary value of that GRAT may be required to be. So there may be an elimination of the ability to zero out GRATs on a go-forward basis. Next. Also important to consideration for our clients is the fact that if they have ILITs, irrevocable life insurance trusts, or insurance in an irrevocable trust, where the policy has been funded via the use of annual gifts, these proposals could have a significant impact on the ability to pay the premium without triggering a gift tax consequence. And some of these proposals limit or decouple the lifetime gift tax exemption from the overall lifetime exemption. And so if that exemption is reduced to $1 million and one can only make gifts to an irrevocable, to a trust of $30,000 a year, that could severely hamper a client's plan and the ability to maintain life insurance without triggering gift tax consequences. So we address those kinds of things as well in the sample letter. Next. As well as, and this is sample letter 3, again, a more simplified format, but also to bring to your attention that it's unclear whether funding separate trusts, such as when a trust terminates on the death of the surviving spouse and then is to go into separate trusts for each of the grantor's then living children, or the issue of a deceased child, those may be deemed to be taxable events. So considering whether one wants to use a pot trust and the implications of using a pot trust are all things that we raise in these letters, and some of these letters, and our considerations for our clients. I can say that yesterday when I was drafting an estate plan, I was now adding a new provision to give the trust protector the ability to terminate and an independent trustee the ability to not subdivide if in their analysis and the exercise of discretion, they felt that the grantor's intentions would be better served by either not subdividing or by creating an outright gift because of the income tax consequences that may now be attendant to some of these trusts, or the GST termination provisions that might be implicated if one of these proposals is enacted. Next. So as you can see, running through these letters, there's a lot to digest, and therefore we really feel that it's helpful to send out a letter, whether you use one of the sample letters we've provided or whether you craft your own, just to alert clients that there really are some significant changes that are proposed and could be on the horizon. None of us know what will be enacted and what the effective date of those enacted legislative changes may be. And so being proactive and letting our clients know can help our clients plan and may also help protect us to document that we've advised our clients that there are things they may wish to consider that they hadn't previously considered when creating plans already in place. Next. So I hope that this information and the sample letters we provided are helpful to you in your practice. And if you're an individual who's contemplating estate planning and watching this webinar, to at least alert you to some of the issues so that you can discuss those issues with your estate planning team and make a better informed decision. There's no decisions that are perfect in this environment, but knowing what some of the pitfalls may be can help formulate how you approach your plan. Thank you.